took place some 18 months ago on the 16th of August 2022, when you stabbed and killed Thomas O'Halloran. You first appeared at this court on the 23rd of August 2022, charged with murder. The trial date was fixed for May 2023 and a timetable set leading to that trial. Later in 2022, it became apparent that psychiatric issues would need careful exploration. In due course, the trial date in May 2023 was vacated and you were transferred to the Newmarket ward at Broadmoor Hospital for assessment and treatment under the supervision of Dr. Jonathan Hafferty, a consultant forensic psychiatrist and research leader at Broadmoor. You have remained under his care since the 1st of August 2023. Assessed as fit to plead, further reports have been provided to this court from both Dr. Hafferty and Dr. Ian Cumming, also a consultant forensic psychiatrist. The most recent reports have been considered by your legal representatives and by the prosecution. Your plea of guilty to manslaughter on the basis of diminished responsibility has been accepted by the prosecution, and I must now sentence you for that offence, along with the offence of the possession of a knife. Thomas O'Halloran was aged 87 at the date of his death. To his family and close friends, he was known as Tom. An impact statement on behalf of the family, written by Dennis Linton, has been read as part of this sentencing hearing. Thomas O'Halloran was clearly a much-loved man, the head of an extended family. Born in Ireland, he had lived in England all his adult life. He worked as a maintenance man and was someone described as a gentle, loving man who spent his whole life working and helping everyone he could. In the statement, Dennis speaks of the huge impact of the attack on the wider family and on the local community of his grandfather. One can only imagine the impact of the violence towards this gentle man and all those who knew him. No words can cover the grief they feel at this senseless killing, nor can any sentence or order from any court ever replace or equate to the loss of his life. Just after 4 p.m. on the 16th of August 2022, a 999 call was made. A young man who happened to be in the area had found Mr. O'Halloran on his motorised mobility scooter, clearly injured and in difficulty. Mr. O'Halloran was travelling along a passageway between Runnymede Gardens and Welland Gardens in Greenford, West London. He was able to tell the young man that he'd been stabbed. He then moves a short distance on his scooter before he slumps forward and members of the public rush to his assistance. On the scooter, he had a basket on the front that was blue in colour with some yellow tape on it, a clear reference to the colours of the Ukrainian flag. It also had a handwritten message, "Support Ukraine against Russia." Also on the scooter was the accordion that he was well known in the area for playing. He was known to busk and to collect money for worthy causes, and I noted that a box containing money was found on the scooter, along with the wallet of Mr. O'Halloran. Members of the public quickly acted to give first aid. Police officers were soon on the scene. Ambulances and the helicopter emergency medical service followed, but sadly, despite all of the efforts of those who provided care, they could not save life, and he died at the scene. He had been stabbed a number of times, including to the neck, the jugular vein, through the rib cage to the heart on one side, and another stab to the heart as well as to the back and to his arms. Some of the injuries are consistent with defensive injuries, showing he had tried to defend himself. It was clearly a savage attack. CCTV shows Mr. O'Halloran travelling on his scooter along Medway Parade in the direction of Runnymede Gardens. He then meets you in the passageway. You are also seen to exit the passageway holding a knife in your left hand, a knife that looks to be something akin to a bread knife. You are also wearing gloves. The CCTV shows you going into an underpass that leads under the A40 in the direction of your mother's home. En route, you can be seen to stop and to deliberately discard the handle of a knife down a drain on Haymill Close, having snapped the knife in two. The handle was recovered, and later forensic analysis revealed the presence of blood from Mr. O'Halloran. You were arrested at your mother's home address just after 1:30 a.m. on the 18th of August. When cautioned, you replied, "Murder, I was in prison at the time." On arrest, you were assessed to be fit to be detained and to be interviewed. A search of your mother's home revealed an Under Armour zip top matching the one you can be seen wearing on CCTV immediately after the stabbing, a knife set with handles similar to the one recovered from the drain on Haymill Close, and the remains of a fire in the garden. Amongst the ashes were the remains of the sole of a shoe, a shoelace, and other pieces of fabric, items to believe ones that you were wearing at the time of the stabbing. Also at that address were other gloves, similar to the ones you are seen wearing on CCTV, and a bottle of bleach you bought after the attack. When interviewed in the presence of your solicitor and an appropriate adult on 2 occasions following arrest, no comment responses were made to most questions. A prepared statement was proffered denying the killing. When shown some stills from the CCTV, you denied it was you. Turning to the antecedents and reports, you are now 45. There are 15 previous convictions recorded against you for 30 offences. The offending history dates back to when you were aged just 13. There are 8 convictions for offences of theft and robbery from 1992 through to 1998, when you would have been 19. In 1998, for offences of robbery, you were sentenced to a total of 4 years in a young offender institution. In 2002, aged 23, for drugs offences, the possession with intent to supply Class A drugs, crack cocaine, and the possession of a prohibited firearm, you were sentenced to a total of 8 years imprisonment. In 2008 and 2010, more minor drugs offences were met with fines, and then in 2011, aged 32, for more offences of robbery, you were sentenced to 12 years imprisonment. In January 2018, for harassment, offences of battery, and breaching a non-molestation order made in December 2017, you were made subject to a suspended sentence order with various requirements. You were in breach of a restraining order in October 2020, and you were imprisoned for 12 weeks. You were recalled to prison in relation to the sentence passed in 2011. It would appear that that recall took effect following the sentence passed upon you in October 2020. You were released from custody at Wormwood Scrubs on the 11th of August 2022, having served in full the sentence passed upon you in 2011. Section 283 of the Sentencing Act 2020 makes provision for a life sentence in circumstances where a court is dealing with an offender for an offence listed in Part 1 of Schedule 15 of the same Act, where that offence was committed on or after the relevant date, that being the 3rd of December 2012, the offender is over 21 when convicted, and both the sentence condition and the previous offence condition are met. Manslaughter is listed in the schedule referred to. The offence was clearly committed on or after the relevant date, and you are over 21. The sentence condition is that but for Section 283, the court would impose a sentence of imprisonment for 10 years or more. And in terms of the relevant guideline here, I will need to have that in mind. Secondly, in terms of the previous offence condition, your conviction for robbery from 2011 is one where a sentence in excess of 10 years was passed. To come within the previous offence condition, the robbery has to be one that in the terms of the schedule, where at some point during the commission of the offence, the offender had in his or her possession a firearm or imitation firearm within the meaning of the Firearms Act 1968. In the decision of Gore, 2010 EWCA Crim 309, the Court of Appeal decided that joint possession in the course of a joint enterprise robbery would be included, even if the offender being sentenced had not had actual individual possession of the firearm in the course of the robbery. Paragraph 42 of the judgment in that case says as follows: however, it must be established or admitted that the offender was a party to the robbery which to his knowledge involved the possession of a firearm or an imitation firearm by one or more of those involved in the robbery. If the sentence and previous offence condition requirements are met, as section 283(3) makes clear, I must impose a sentence of imprisonment for life unless I am of the opinion that there are particular circumstances which relate to the index offence, the previous offence, or to you that would make it unjust in all the circumstances. In relation to the previous conviction for robbery, I am told there is no finding of possession of a firearm on the record, and that issue is very much in doubt. Mr. Patterson, King's Counsel, very fairly says that due to the uncertainty about the previous matters, I could and should not find the previous condition to be met. I note from the psychiatric reports the detailed analysis of your time in custody. There do not appear to be any concerns or matters raised in relation to any mental health matters until September 2020. There is a reference to you trying to take your own life on a number of occasions, and that your mother had concerns about you suffering from some form of delusional disorder. In the autumn of 2020, there were reports of you hearing voices and the possibility of you having paranoid schizophrenia. In October 2020, you were moved from one prison to another, to Wormwood Scrubs, and then the following month to Olney. At the time, you were prescribed an oral antipsychotic medication, and you were taking that between October 2020 and early 2021 when it stopped. At that time, you said you no longer heard voices or had intrusive thoughts. Reviews continued throughout 2021. In February 2022, there was an altercation with another prisoner, and you were put into segregation and commented that you were being monitored due to your unpredictable behaviour. Then in March 2022, you were moved back to Wormwood Scrubs. An entry in the prison records comments that you'd had an enduring mental illness and were not on medication. You said on the 7th of March 2022 that you had been previously diagnosed with paranoid schizophrenia and had been on medication. Dr. Cumming notes in his report, where much of the history that I've set out is given, that in the notes leading up to your release on the 11th of August 2022, there are no entries relating to mental health. For the purpose of this sentencing hearing, I have reports from both the psychiatrists I have mentioned. They are highly experienced and respected experts. They are both approved under the relevant section of the mental health legislation. The relevant reports from Dr. Cumming are dated the 4th of May 2023 and the 10th of April 2024. Those from Dr. Hafferty are dated the 10th of December 2023, the 27th of February 2024, the 25th of March 2024, the 2nd of April and the 30th of April 2024. I also have a note of a consultation between leading counsel for the prosecution and Dr. Cumming dated the 12th of April 2024. Turning to the sentencing guidelines, the maximum sentence for manslaughter is one of life imprisonment. For offence of manslaughter by reason of diminished responsibility, there are specific guidelines issued by the Sentencing Council. The first issue is to assess the degree of responsibility retained. Considering the features of the case and what is set out in the reports, I am satisfied that this case falls into the lower category of responsibility retained. I note in particular what is set out by Dr. Hafferty at paragraphs 59 to 60 of his report. If a custodial sentence is to be imposed, the guidelines give a start point for lower level responsibility retained of 7 years custody with a range of between 3 and 12 years custody. I also need to have regard to the guidelines on sentencing offenders with mental disorders, developmental disorders or neurological impairments, as well as the guidelines on bladed articles and offensive weapons, discount for plea and totality. In this case, there are a number of significant aggravating factors set out in the manslaughter guidelines that are present. I've already mentioned your previous offending, including offensive robbery. I note that at the time of this offence you were on police bail, although you were in prison having been recalled until just before the incident. The proceedings you were on bail for were not proceeded with. Here, the victim of your attack was particularly vulnerable. The offence involved the use of a knife, and your acts after the offence were designed to conceal or hide your involvement. The carrying of a knife by you when you leave home suggests a level of planning or premeditation, as why else would you have one? That does not mean there is anything to suggest a plan to attack Mr. O'Halloran specifically. The factors I have listed would increase the start point for any sentence by some margin, up the range for lower responsibility retained to one of 10 years imprisoned before any allowance for plea. On factors reducing or reflecting personal mitigation, I note that some remorse has been expressed by you through the interviews with Dr. Hafferty whilst he's been treating you. I've also referred to your plea. If passing a sentence of imprisonment, the sentence after plea would be reduced by some 25%. Next, I need to consider dangerousness. The test is this: is there a significant risk to members of the public of serious harm occasioned by the commission by you of further specified offences? On the material here, that test is clearly met. Both expert psychiatrists agree. I note in particular on this issue what is set out by Dr. Hafferty at paragraph 61 of his report, and I quote, "I do consider Mr. Byer to be a very dangerous man. The nature of the offence and the nature of the death of the victim were grave and extremely violent. Whilst Mr. Byer does not have a previous history of highly serious violence, in his forensic history or psychic history of his mental disorder, he has clearly shown the ability to discharge lethal aggression against a vulnerable victim with no provocation, with no rational motive, and with little in the way of warning signs that could identify his risks by those non-medical individuals who were supervising him in prison before his release, or those who encountered him immediately prior to the offence, which occurred days after his release. Below, I will consider how these risks can be managed from a psychiatric perspective. The real issue on sentence in this case is that between a hospital order with restrictions as provided for in sections 37 and sections 41 of the Mental Health Act 1983, or an order under section 45A of the 1983 Act, what is known as a hybrid order. Turning then to mental health issues. Both forensic psychiatrists are clear that in their professional opinions you are someone suffering with paranoid schizophrenia, and that a hospital order under section 37 of the 1983 Act with a restriction order under section 41 of that Act is the most appropriate and best way to balance between treatment and the wider interests of the protection of the public. In his report dated the 10th of April 2024, Dr. Cummings states as follows: if sentenced under section 37 of the Mental Health Act, Mr. Byer would remain in a secure inpatient unit for the foreseeable future in order to receive the necessary treatment and rehabilitation. Mr. Byer's diagnosis of paranoid schizophrenia makes this disposal a possibility. I am aware that a bed remains available at Broadmoor Hospital. I would also recommend the use of a restriction order. It is clear that in terms of this offence, the use of such is indicated. The offence was grave, high profile, and of an elderly man in a motorised chair occurring without provocation. Mr. Byer has a history of violence, and the use of a restriction order is needed to protect the public. I've set out some further extracts from the report of Dr. Cumming in the written sentencing remarks that will be available at the end of this hearing. Dr. Cumming then goes on to deal with a hybrid order. And he says this: in terms of a hybrid order, this disposal has a penal element and the release regime is different. If Mr. Byer was made subject to Section 45A of the Mental Health Act, he would remain in a secure unit for the foreseeable future so that he would receive the necessary treatment. If his mental health were to improve to the extent that no further treatment is necessary, then Mr. Byer would be remitted to prison to serve the rest of his sentence. On arrival in prison, the Section 45A order would cease to have effect and he would be referred to the Mental Health In-Reach prison, team in prison for ongoing mental health input, but he could not be forced to comply if he did not wish to do so. It is too early to say how well Mr. Byer will respond to treatment. At the current time, his improvement is partial. He's shown an antipathy to mental health services, and when he's been more unwell in 2023 at the time of the offence, he lacked insight into his illness and was affected by ongoing command hallucinations, though still unable to function reasonably. I am concerned that though there is a risk structure through the hybrid order, and in consideration of the above issues, no enforcement of the Mental Health Act 1983 in prison, and his lack of insight and command hallucinations means that he may pose a significant risk to others. Though ultimately the matter for the judiciary, I conclude that the use of a hospital order with a restriction order is the more appropriate recommendation to reduce risk. This, I note, is further amplified in the note of consultation, where Dr. Cumming adds this: this is a man who has still not recovered. I do not know whether he ever will. He is likely to remain on medication for the rest of his life to manage his illness. When unwell, the illness is difficult to see or penetrate. They do not want a person with command hallucinations in prison. The command hallucinations present a risk. The MHA does not apply in prison and they cannot compel treatment. They could send him back to hospital, but Byer's risk of violence is linked to his illness. There are a number of other paragraphs from that note that I've added to the written sentencing remarks. In his report, Dr. Hafferty makes similar observations, and I note in particular, firstly, under when considering the protection of the public, he says this: the defendant has shown a good response to pharmacological therapy. His psychological assessment, and treatment has only begun and is likely to be difficult for the reasons stated. In my opinion, Mr. Byer requires the supervised care of a specialised forensic service, and I consider this need to be long-term and possibly lifelong. If he should become non-compliant with his medication again, I believe the risks the defendant poses of violence are potentially grave. I do not believe this supervision and managed treatment can be effected by prison healthcare services, the parole board or probation services. In the event of Mr. Byer returning to prison after hospital treatment to complete the determinate part of his custodial sentence as part of a Section 45A hybrid order, in my opinion, the parole board can offer little in the material assistance of public safety in this case than to follow the advice of clinicians, since Mr. Byer's risk is extant from his mental disorder, schizophrenia, personality disorder and substance misuse. Such effective interface between prison clinicians and the parole board is far less likely to be as effective and comprehensive as the interface between forensic psychiatrists and the Ministry of Justice, the first-tier tribunal, offered by a hospital order route, in my opinion. And his summary at the end: I've considered carefully the applicability of a Section 45A hybrid order in this case, and also considered the opinion of Dr. Ian Cumming, who's provided psychiatric evidence to the court. It is my view that a Section 45A order would not be the most appropriate disposal in the defendant's case. I agree with Dr. Cumming that that is not the preferred recommendation from a psychiatric point of view for the reasons stated above. Dr. Hafferty gave evidence during the course of this sentencing hearing. He adopted his reports and agreed with the summary conclusions that I've set out. He set out the way in which treatment can be given and the issues around management in the prison estate. He expanded on the reasons why the preferred course here is that you stay within the secure hospital environment as opposed to the prison estate, as well as the extensive treatment that is required. The treatment is going to be long-term and probably lifelong. He confirmed that it is clear that the best way of protecting the public is through a hospital order with a restriction order. He cannot be definitive as to the timing. He confirmed the findings in his report that the treatment is at an early stage and that you will be in a high security place for many years and then possibly go to a lower level of security. And there is a possibility that you may remain in hospital for the rest of your life. You will certainly need long-term and possibly lifelong treatment. The leading case in this area of sentencing is the decision of the Court of Appeal in Vowles and others from 2015. I've considered in particular paragraphs 51 to 55 of that judgment. There are a number of other authorities that I've been referred to and considered, including that of the case of Paul Surrey from 2022 and Walker from 2023. Turning then to sentence. In my view, the conditions in section 37(2)(a) are met in this case. You are someone clearly suffering with paranoid schizophrenia, a chronic mental illness. Taking into account the factors set out in the case of Vowles, namely, 1, the extent to which you need treatment for the mental disorder from which you suffer; secondly, the extent to which the offending is attributable to the mental disorder; thirdly, the extent to which punishment is required; and fourthly, the protection of the public, including the regime for deciding release and the regime after release. I am entirely satisfied that the appropriate way to deal with you is by the making of a hospital order with restrictions. I know there is a place available to you within the Newmarket ward at Broadmoor Hospital under the continuing care of Dr. Hafferty in all the circumstances, but in particular as to what is said about the regime on release. Whilst I've given consideration to a hybrid order, I have come to the view that the passing of the penal element is not likely to assist in the management of the very obvious risks that are present here. I am also satisfied that this is a case where, having regard to the nature of the offences and the offence of manslaughter in particular, and the risk of you committing further offences if at large, that it is necessary for the protection of the public from serious harm that I should further order you be the subject of the provisions of section 41 of the 1983 Act. So I will make in addition a restriction order. The sentence here is a hospital order with a restriction in relation to both counts on the indictment. If the statutory surcharge applies in this case, the appropriate order may be drawn up. You may go down.